So should I start?
Yeah.
Okay. As it is rightly said, a good settlement is better than a good loss. This was quoted by Abraham Lincoln, first President of America. Good afternoon, everyone. I, Mudita Dubey, on behalf of Legal Desire Media and Insights, welcome you all to our conference on future of alternate dispute resolution in pre and post pandemic era. Hope you all are safe and healthy. Alternate dispute resolution is one of the most blooming fields in India. We all are aware that the Indian judiciary is overburdened with cases, so many people are looking for the alternatives to resolve their disputes in a speedy manner. This is where alternate dispute resolution plays a huge role. Alternate dispute resolution is an extremely wide field. It provides a range of alternatives to resolve one's dispute like arbitration, conciliation, mediation, various ombudsmen, etc. It upholds a lot of people for the young generation in India and abroad. The Department of the Alternate Dispute Resolution aims to create awareness regarding this field amongst the young generation of law students. This field is yet under research, and we aim to do extensive research in unexplored areas of field and make young minds aware about it. This department would regularly organize panel discussions, webinars, competitions, roundtable discussions with industry experts to pave a roadmap for ADR across the globe in both practice areas and legal academic curriculum for introductory certificate courses in ADR along with the specialized post-graduation programs taught by the industry experts. Prior to COVID 19, our judicial system was jammed with calendars, a shortage of judges, minimal support staff, which simply led to the minimal time for judges to commit to an active effort to engage the parties in resolving their disputes. Rather, the cases were left to dawdle for many months, often years until reaching standards and goals for the case. This led to a waste of time and money both and made people shift towards opting a different approach and resolving their disputes. As we all are ready by this current pandemic, the alternate dispute resolution, that is the ADR, is possibly no longer an alternative to transferring the court system, but rather the only sustainable method for the speedy resolution of disputes. This virtual conference aims at making people understand the importance of ADR and how ADR could have a huge impact in order to resolve disputes. This conference also deals with the issues relating to impact of COVID-19 and ADR and many other issues. The conference is defined to produce maximum participation, learning, and networking opportunities. Our first speaker for the day is Mr. Mrityunjay Kumar. Mrityunjay Kumar is an international dispute resolution lawyer who holds a master's degree from University of Melbourne, Australia. Mr. Kumar specializes in international commercial arbitration, energy, and resource laws. His post-qualification experience spans over 8 years of of cross-culture, cross-industry, and cross-functional roles in large and small concerns in India, Australia, Malaysia, and Indonesia. He would be talking about key consideration for parties in conducting a virtual hearing. We welcome you, sir.
Thank you, Lisa. Thank you very much. So today I'll be talking about the key consideration for the parties while conducting virtual hearing. As Mudita pointed out, due to the pandemic, we are moving towards virtual hearing, and parties are finding it more cost-friendly and time-saving. However, there are a few challenges that must be considered by the parties beforehand. There are many, but I'll be talking about 10 pointers today. These are the basic points which parties must consider beforehand to avoid challenges of the award afterwards and to ensure the smooth proceedings. So to start with, the very first point is the preliminary agreement. So as we all know that due to the virtual hearing was there in the market, but it was not opted for, not opted by many people or many consumers. But due to this pandemic, virtual hearing is getting traction, and people are preferring more and more to resolve their dispute through online procedures. So as it was not in vogue earlier, so it is a high probability that your agreement would not be having any provision as to virtual hearing. So it is better while you are going for a virtual hearing, it is better for you to agree in advance about the procedure that has to be followed during the virtual hearing. Otherwise, the other party may have that on a point to challenge the award on the basis of due process. And we all know that the due process is a very strong point to challenge the award. So it is better to agree beforehand about all the procedures and the methods that has to be followed during virtual hearing. For example, I would like to mention a recent case, the case by German banks against Spain in a renewable energy transaction. So the tribunal held like passed an order that due to this pandemic they are unable to travel and the proceeding must go for a virtual hearing. But the Spain challenged it, the order on the basis of misrepresentation. So you can see here, if the defending party doesn't have any strong defense in case, because Spain has did these challenges like this is the fourth time, so we can understand that they are not having a very strong defense. So if the opposite party doesn't have any strong defense at hand, they would like to explore each and every point you provide to them to challenge the award. So in that line, before going to virtual hearing, make sure that you both parties have an agreement to that effect. The second point is platform selection. So platform selection is your hearing room or courtroom or conference room. Today, there are many online service providers like Microsoft Teams, WebEx, GoToMeeting, BlueZeens, Zoom. So parties have n number of options to choose from. And while choosing their online platform, it is advisable to consider the confidentiality provision, like what all the measures they are taken by the online service provider, then the quality of audio and video, and then subgrouping, whether the platform provides subgrouping or not, and then the screen document display. So these are few points, and apart from that, there are other points as well. It will depend upon your particular case. So you should first explore these all options and are available to you, and then select the best suited platform to your particular case. Besides, there are many arbitral institutions like Stockholm Chamber of Commerce, like and then International Arbitration Center, then International Dispute Resolution Center. They also provide a customized dispute resolution platform. So the parties can go for those platforms as well. The next point is third-party operators. So while you choose a platform, when you are done with choosing the platform, it is advisable to go for a third-party operator. Some like if you have in-house team already available, then you can handle it by yourself. But in the most of the cases, the consumer doesn't have, the client doesn't have in-house ready team available. So it is advisable to have a third-party operator. It will make sure any preparatory requirements, then the break-fix methods, and the availability of all hardware. So the party will be free from these all problems, because they don't have to worry about the technical issues, hardware, and all those, and they can focus more on the substance of the case. So after choosing a platform, hire a neutral third-party service provider to handle the platform. Then the next point is also related to platform only, but that is quite different. That is a separate platform for team communication. During the procedure, it is often that you need to communicate with your team members, and I think all of the platform provides a chatting group, like chatting services. You can chat through all the involved parties through a chat box, and you can select an option like which message, like this message you want to shoot to whom. But sometimes it is possible that due to accident, like accidentally you disclose the information or the message to other party instead of your team member. It is a possibility. So to avoid that, it is better to have a separate platform to internal team communication, not on the same platform on which the hearing is going on. So it will ensure that accidentally you do not disclose your information or message to any third party or like other party involved in the hearing proceedings. The next pointer is ensuring confidentiality and cyber security. When we talk about use of information technology, cyber security and confidentiality is a very common and critical issue. Many countries have a detailed law on this, and they have a different requirement depending upon jurisdiction. It can be stringent and it can be lenient as well. However, the basic point while you are using information technology to ensure the confidentiality and cyber security is to agree upon minimum level of security as to transmission of the document, storage of the document, and the access to the third party. So this can be like in the form of encrypted storage or encrypted transmission. Besides, while you are using third party, then the party must give due consideration to the terms and conditions to ensure that it is acceptable to the parties. And besides, it also is important to make sure that these terms and conditions doesn't provide any right in data to that third party service provider. Otherwise, if you do not look into it properly, and if the clause says that the service provider has a right to copy the data, then your confidentiality is compromised. So it is advisable to the parties to analyze the terms and conditions properly and talk to the third party to ensure that they doesn't have any right on the data and they are bound to the confidentiality agreement. Then the next point comes to with regard to disclosure only. It is disclosure of the participants. So it is a very small point, but it helps enhance the confidentiality of the procedure. So while conducting the hearing, there is a possibility that apart from the lawyer and the client, other relevant party will be available at the client's site or the other party's location. So the party should take the responsibility that they will, before the start of the hearing, disclose all the participants available at that location so that the other party will have option to agree or object if the other party doesn't want any person to be available at during the hearing. So this will minimize the chance of future rifts and future disputes as to the confidentiality of the proceeding. The next 8th point is familiarity with the technology and the test session. This point I think does not need any explanation, as it is very self-explanatory. All the parties involved must be familiar with the technology and the software that is being used, and it is advisable to the parties to have a full test session beforehand, including the tribunal, the lawyers, and the witnesses. So it will help to secure that during the process, if any problem occurs, the technical glitch occurs, it will be taken care of easily. So test session is recommended. If you have a time, you should do it twice or thrice to make sure that the during hearing the procedure goes smooth. Then comes the backup. It is one of the important points to ensure the fail-safe. Party must in advance agree on the backup procedure. Suppose if some glitch happens or the procedure is disturbed due to some technical issues, then what will happen? Either it is going to be regarded as short adjournment. If yes, then how the other party should intimate the tribunal and the first party with regard to this breakdown? Through email, through SMS, through teleconference. So whatever the mode is, it must be agreed in advance. And besides, they can also agree, like the party can consider that it should not be treated as a short adjournment. Rather, the party should continue the hearing through teleconference. So whatever the more party considers, it must be agreed beforehand. Otherwise, in case of technical glitch, as I said, the procedural due process is a very strong point to challenge the award. So the other party may have an option, and they can challenge the award later on that on the point of due process, that they can say that the process was not standard as defined by the contract. So it must be agreed how the party is going to tackle any disturbance during the hearing. And the last but not least is the termination. So termination of virtual hearing is a very simple if both the party agree on the termination, because everyone knows that it is the arbitration enjoys party autonomy. Party autonomy is the fulcrum of arbitration. So party has each and every right to terminate the proceedings. But what happens if one party says that the virtual hearing is not suited to the current case at the hand, but the other party has a different opinion? In that scenario, it is again a different point of dispute. So I think in this scenario, the party should give the authority to the tribunal to decide whether the virtual hearing is suited to the particular case at hand or not. If not, then the tribunal should be given power to terminate the issue. And that should be agreed that when it is done, this should not be a point of, it should not be used as a ground to challenge the award. So this will enhance the credibility and finality of the award. So this is all from my side, these 10 pointers, which I suppose that party should consider before opting for the virtual hearing. Thank you. Mudita? Over to you, Mudita.
Thank you, sir. That was an insightful session. You also highlighted that what parties should be taken care while having a virtual hearing, and you also highlighted that parties should have a backup plan as a breakdown may happen. Now we will move forward with the question answer session.
Sure. Do you have any questions?
Yes, sir. Sir, Jair sir wants to ask you one question.
Sure, please.
Okay, so first of all, let me congratulate you, my dear friend Mrityunjay Kumar, Dr. Kumar, for your very thoughtful, objective, and very useful lecture. Indeed, you touched the very key aspects of a virtual hearing. But my question would be, how is your experience so far on the preparation of the ADR providers to respond to each one of these 10 specific items that you listed? Are you finding ADR providers ready to face these specific challenges? And are they, according to your experience, Dr. Kumar, really responding to the concerns that you've brought up along your questions?
Yes, Professor. In my experience, I have been recently in touch with AIAC and SIAC, Singapore. So due to this virtual hearing, AIAC, as I talked about the disclosure of participants and then technology. So they are taking care of this, because in one case, I cannot disclose, and to be honest, I'm not fully aware about that case. I was consulted on the point that it was on an informal basis. So this platform issue, like how should we manage the platform? Because if one platform is provided, and then there is a probability of disclosing some information accidentally. So as I said, it is on to the parties. The service provider cannot give you each and everything. So it is on to the parties to look forward for some different modes available to them for international team communication, because the service provider is only liable for providing the platform for hearing and not securing your personal issues, like securing it against your personal accidents that due to which you disclose some information. So they are taking care of it, but it is on experience based. Whatever the problem they are encountering, they are providing measures to tackle that problem. So we are still, there is still a long way to tackle with these all issues, because one of the important issue is cyber security and confidentiality, which is very hard to make foolproof. Because in confidentiality, depending on the jurisdiction, one jurisdiction has a different requirement, minimum requirement, other has a different minimum requirement. Suppose you opted for the minimum level of requirement, which is not up to the mark in the jurisdiction where you are enforcing your power, then that would not be accepted. So these issues are still needs to be taken care of, and that can be taken care of together, because if one center has a different requirement, another has a different, it cannot be useful for the parties. So it should be a uniform code for ensuring confidentiality and cyber security. So it is still a long way to go, Professor.
I think so. Thank you, Dr. Kumar. Very, very interesting. The issues that you are bringing up now, they are actually quintessential for us to be discussing about, because this is really the heart of the procedure. And as you already said, uniformization, maybe standardization in the near future is a probable trend that you're going to face. And also, we will need to have all the providers somehow on the same page. But great. So let me just leave the floor open for other questions, because it's really a great speech that you delivered right now, and for sure there will be other questions being addressed to you. Thanks, Dr.
Thank you, Kumar. Thank you very much.
So there is a question: can we incorporate the confidentiality clause in separate NDA for the purpose of arbitration?
Could you come again, please? Could you come again, please?
Can we incorporate the confidential clause in separate NDA for the purpose of arbitration?
Yes, we can easily, because it's a total autonomy of the parties. But make sure if you are making a different document, a different agreement as to any clause, try to make sure that it is referenced in each and to your main contract. Otherwise, it will not have any effect. It doesn't have any link, and it will not have any effect on the main contract. So yes, you can create a new NDA as to ensuring the confidentiality, but make sure to connect it with the main agreement by referencing.
So there is one more question. How virtual hearing would be suited in case of the client is poor and not be able to access the internet?
Uh, to be very frank, if you are going for international arbitration, I said you are not that poor that you cannot afford internet, because eh, take example of India, every village has a smartphone available, and they are accessing internet. So I don't think that any client would be in a scenario that they are not facing, like they are facing internet issues, that they cannot opt for it or they cannot avail it. If they are, then I'm sorry, I do not have answer for that.
So next question is privacy concerns. As you know, sir, hacking is quite prominent in today's time. So with regards to maintaining the secrecy of the matter, what protocols should the parties follow?
With regard to this, there are institutions which are providing guidelines and full detailed directions, like ICC note, the part like you can refer to ICC note or IBA guidelines on cyber security. So they have provided detailed procedure to avoid these kind of issues. So it is better to refer to those notes prepared by ICC with regard to international arbitration and the guidelines on the cyber security provided by IBA. Because to be frank, I'm not an expert in these all issues.
And so what should be the ideal choice of platform for conducting an online arbitration?
It depends upon case to case. Like if your case is a very small one in size, like considering the time and the documentation, you can go for any minimum option like Zoom or BlueJeans, and rest depends upon your requirement. So first you have to chalk down your requirement, like how complex your case is, how complex you want to use the document presentation option, how many people are going to participate, whether you need a subgrouping or not. Depending upon that, your like you should choose the platform. The answer is like it is dependent upon case to case. There is a no uniform platform that can be chosen for each and every case.
Okay, thank you, sir.
Thank you, Mohit. Thank you very much. Hope it was helpful.
Very much so.
Our next speaker for the day is Mr. Gevaerd. Gevaerd is a founding partner at Gevaerd and Associates, a well-regarded Brazilian boutique law firm specialized in commercial law. In addition to serving as a state attorney to the state of Paraná, Mr. Gevaerd is a domestic and international arbitrator as well as a cross-culture international commercial mediator with the experience in the US and Brazil. He is also a professor of corporate law, international law, conflict of laws at the Pontifical Catholic University of Paraná, specialist in development law, and holds a Master's of Laws and a PhD degree in corporate law from Paraná State Federal University Law School, Brazil. Mr. Gevaerd has an LLM in dispute resolution, concentration in arbitration from the Starus Institute of Dispute Resolution. He has been appointed in 2019 as the Starus Institute Ambassador for Brazil. He teaches a segment as the visiting faculty at the Starus Institute Summer Seminar on the US law, legal writing, and ADR, and is currently the International Director for the Academic Affairs of Brazilian Center of Mediation and Arbitration, where he is also President of the International Editorial Committee of ADR, Brazilian Law Journal. Sir would be talking about how cross-culture awareness can help neutrals negative COVID-19 international conflict. We welcome you, sir.
Thank you very much, Mudita. And again, I would like to greet my dear friend, Dr. Kumar, who delivered this wonderful lecture on the key issues about virtual hearings. And also, I would like to thank all the people from the Legal Desire, which is a quite amazing institution, a global leading legal media institution, which is providing us with the opportunity of discussing so interesting aspects of the law and of our contemporary challenges and so on and so forth. But let me begin by telling you that although Mudita brought up, I mean, a quite long a curriculum, CV, with many qualifications, if they are true or not, this is a different thing. But I like to define myself as a student, right? So, and it really makes me happy to be speaking in a setting which is led by this institution, which says that it is trying to bring the legal fraternity together. I think that this is what really counts. We are a fraternity of practitioners that we are trying to make sense of what are the consequences of this pandemic. So while Dr. Kumar brought so competently the many different challenges that this new reality, this new online reality is bringing to us, I would like to focus on a different aspect of what is happening right now. So, and again, the title, the topic which is proposed by this 2 days virtual conference is the future of ADR in the pre and post pandemic era. So the first thing that I would like to ask, the first thing that I would like to tease you with is, are we really living a new era? Are we really facing this pre-pandemic era? So in the past, the years were as before Christ, after Christ. So are we in a situation in which we will count the years according to them being pre-pandemic years and post-pandemic years? Well, I don't know about that, but what I can for sure tell you, and this was even more clear to me after listening to Dr. Kumar, is that there are some trends, some new trends that for sure came to stay. And not only that, but this trends will probably meddle, interfere, influence the way that we practice ADR from now on, from now towards the years that are ahead of us, right? So, and I would like to talk with you about five, I would say five basic trends that as a seasoned, as an experimented arbitrator and mediator, as a node practitioner, if you will, I'm getting from this. Okay, so I'm getting here that Dr. Kumar is claiming that he's not a professor. You are wrong, my friend. Professor is someone that teaches others what they should learn. And if you are not formally a professor, you acted as one, I mean, this afternoon. So I'm sorry about not being that formal, but yes, Dr. Kumar, if you're not, you should be a professor because you're very talented with words, and you just taught us about some very very key issues on the online hearing. But going on with that, so this lecture, this speech of mine tries to work with the cultural awareness, right, of what is going on for us to identify this trends that I was talking about, right? So the first and the very obvious, the very clear trend that we are seeing right now is that, yes, we definitely moved from the in-presence activities to the online setting. And this, I really believe, is here to stay, right? So this is the A side. This is the front of the page. This is what we can actually see. So online, digital, technological component of this activity of ours came to stay, right? No doubt about it. And this is very progressive. This is very technological. As Dr. Kumar said, yes, there's a lot for us to go on that. ADR providers will have to organize themselves and so on. But yes, we will stick with our online thing from now and towards the years to come. And to tell you the truth, I'm teaching a lot online. I'm working as an arbitrator, working as a mediator online and everything, and I'm liking it, you know. So everything was on the radar before, but we somehow moved 5 years in 5 months, and there is a digital etiquette getting in place. So people already know when to mute their mics, when to turn on the cameras. So you can somehow see and check some facial, some expression, some body language on in the online realm and everything. And I guess that we are doing good so far. ADR providers are trying to do their best in order to respond to the demands that Dr. Kumar just brought up in his speech and everything. But okay, so this is what we can see. But there are some things which come in a paradoxically opposite side, which are really intriguing me, and I would like to expose them to you in order for us to hopefully discuss the issue. So first of all, the first flip side of this online technological advancement is some issues regarding how mankind deals sees ever with cross-cultural awareness. So there's a couple of questions that I keep asking myself and that I would like to share with you. First, how parties, legal counsel, companies, ADR providers, especially in the international realm, will get to know and ultimately develop rapport, trust, and confidence towards new arbitrators and new mediators in this digital realm. Yes, we can see some facial, some body language, but mankind develops confidence. Mankind develops respect through, since ever, from this physical, personal acquaintance, personal relationships. So second, how trust and reliance will be established in an environment totally immersed in the coldness of the digital acquaintance, where eyes seldom meet other eyes, physical proximity does not exist, and the ever-existing empathy game has no material expression, right? Again, how more than that, how cross-cultural abilities, the ability of reading a different culture in the international realm, the ability of learning a different cultural language, how we're going to develop this, and these abilities are almost totally dependent on physical proximity without arbitrators and especially mediators traveling around, getting immersed in different physical environments. In other words, how to learn the other country's cultural language without immersing into that complex culture through traveling, chatting, smelling, tasting, listening to it in all its livelihood and exuberance. So here, my friends, what I'm claiming is that international arbitrators, international mediators, international ADR practitioners are different from, other practitioners. Why? Because they are like international merchants. For instance, Dr. Kumar the other day was arbitrating in Singapore. Okay, he was arbitrating online, but somehow he has been there previously. He has been known in Singapore, maybe in Malaysia, maybe in Australia, maybe in Brazil, maybe in the United States. I mean, everywhere. He has been known, identified. He has been trusted as a very competent international ADR practitioner, maybe an arbitrator or a legal counsel or whatever it is. But the thing is, how we are going to get new people, newcomers, because this is, the Legal Desire is an institution that is trying to train, trying to break news for young practitioners, young students of ADR. So how these guys, how these boys and girls, men and women will get to the field if they are not being able we don't know up to when, if they are not being able to soak themselves into different cultural settings. So this somehow concerns me because I can see here a specific trend which goes in the opposite direction of the technological development. Whereas the technological development is something very progressive, something very straightforward, something very new and exciting, right? Somehow we are seeing that there's a trend coming in the opposite direction, a very conservative trend, which will favor pre-pandemic era ADR professionals in detriment of post-pandemic era ADR new professionals. Why? Because the old, the dinosaurs, the ADR animals that were there for 10 years in the past and so on, they are already known. Everybody can identify them based upon this physical acquaintance as culturally competent across jurisdiction professionals. And this concerns me a little because how we are going to overcome this and how we are going to reception, how we are going to open the field for this new generation, which is who's not having the chance of really practicing the cultural awareness of what being an ADR professional is in a very diverse world, right? So second, the technicalities that Dr. Kumar has just mentioned to us. For instance, how can one warrant that a deposition in an online environment, which is being made in Rio de Janeiro, for instance, or in New Delhi, with lawyers in Dhaka and arbitrators in New York, let's say, London, how can one warrant that this deposition will not be somehow coached by a technological device, gadget, which is deep into the ears of that specific witness, right? And beyond the possibility of detection of that third party operator of the system and so on. How to guarantee that a caucus or a private meeting inside a mediation procedure will not be somehow compromised by a hidden recording device, which will, seriously break the confidentiality of the whole procedure. And here I see a third trend, which concerns me a little bit, because there is also a conservative tendency. I see a conservative tendency coming in terms of favoring traditional, well-established, old, and well-proven ADR provider, law firms, and ADR practitioners in detriment of new and yet unproven ADR providers. Dr. Kumar told us a bit earlier that he's been working with SIAC or SIAC in Singapore, where our friend Gary Bourne is the chairman and everything. So as well as the CIMC, where George Lim, our good friend, is one of the chairs when it concerns to mediation. Okay, fine. So yes, that's what will happen. We will have a more prominent role of SIAC in Singapore, of ICC or AAA, CPR in the United States, GEMS maybe, right? Not to mention the many traditional ADR providers of South Asia and everything, in detriment of new, innovative, and creative new ADR providers that would possibly come to the picture if this pandemic was not wrecking a vogue as it is. So again, we have the online trend, very progressive, leading us to new horizons, while we have old practitioners, proven well experimented practitioners, and also very well established and traditional ADR providers being able to respond to the challenges of this new time in terms of confidentiality, safety, certainty, secrecy of the whole procedure, and this somehow concerns me as for the advancements that we could have, right? Again, ethical standards will be more and more important. New ethical standards, a new set of best practices. As Dr. Kumar also told us, ICC is trying to come out with some new privacy guidelines to be applied to this new online setting, right? And this is great, but again, we will have a conservative wave favoring traditional and very well established ADR providers in detriment of new institutions that could bloom in this new setting. But unfortunately, because of many backlashes and everything, we might be seeing this conservative wave somehow ruling over the whole ADR environment, disfavoring somehow the new generation, which has not had the opportunity yet to get acquainted, to get known in the field. The last trend, the last tendency that I would like to shed some light on now, not to exceed the time that was allowed to me, is that I see very clearly, my dear friends, that arbitration tends to be trumped by mediation. Why? Because, of course, the kind of challenges that we are having now, either at the contractual, either at the international trade specific realm, or into the very procedures, the procedures of the ADR world themselves, they will demand a flexibility. They will demand a certain wiggle room that are very keen to, that is very keen to mediation and not arbitration. What I'm trying to say is that this online thing that we are seeing along the pandemic in this, post-pandemic era, right, will somehow bring with it a set of conservative trends that might compromise the reception of new and fresh ADR practitioners, young ADR practitioners in the field. And this concerns me a lot because we might be going back to a time in which arbitration was and ADR was very much an activity of a selected, limited, and close group of practitioners, ADR providers, law firms, etc., etc. So when Mudita just began and opened this conference, she said, and I wrote this down, that ADR is blooming, and that's true, Mudita. ADR is blooming, and maybe it's now, you said that, Mudita, it is the only sustainable method to solve problems in the international realm. And here, what, and why? Because it's it was becoming more and more flexible, more and more suitable for people to discuss the differences. But Mudita, let me ask you now, with all these caveats, with all these safeguards, with all this cautionary measures and this framework that Dr. Kumar was telling us to secure, to warrant the soundness of the procedure, wouldn't we going back to the state? Because of course the state, the state jurisdiction has many privileges that respond exactly to the same challenges that Dr. Kumar is bringing here as well. So up to what point, notwithstanding the progressiveness of the online trend, we are not getting backwards in terms of flexibility and everything. So Mudita, I will finish now to listen to the questions, right? This is to tease you. This is to provoke you. This is just to make you a little restless about what is happening right now. I hope that none of this happens, right? But for sure, we need to discuss this new trend. Thank you very much.
Thank you, sir,
Right.
for sharing your knowledge and regarding the international arbitration and making it an insightful session. So I would like to ask some questions. Uh,
Go ahead, please.
do you think difference in cross-culture beings about communication barriers because of norms followed by arbitrators or mediators belonging to different parts of the globe differ? The ideologies and methods of approaching dispute differ.
Okay, can you just repeat the last part of your question?
As their ideologies and methods of approaching to the disputes differ. So,
That Go ahead,
Is
please. I'm listening to you.
is
Yes,
there
but
is there a difference in culture brings about the communication barriers because of the norms followed by the arbitrators or mediators in different parts of the globe?
absolutely yes, Mudita. Let me give to the audience some examples, right? Before this session, before the beginning of the session, I was listening to the BBC News, right? And they were discussing basically what happened in Lebanon, right? The blast, the explosion that happened in Lebanon uh, a little time ago, right? So some of the most important subjects that we would discuss in a post-pandemic era as for the impact in the agreements, in the trade agreements, are force majeure, right? Adaptation of contracts because of excessive, some of the provisions of trade agreements that were entered into in the pre-pandemic era are too burdensome over some parties. And so we need to adapt. We need to somehow adjust a tribunal, an arbitral tribunal, or a mediation would have to soften these provisions and everything. And then I ask you, was really unexpected what happened in Lebanon with that unfortunate blast? Really, that nobody knew that there were tons of ammonia stuck somewhere in that port, and that there's a specific material would blow up at a certain point. And okay, the answer. So, for instance, is there really credible that the news about the pandemic were broken up timely when the first signs of the pandemic happened 4 or 5 months ago? I'm not saying that someone spoke up or not. What I'm saying is that, is it really credible that no one knew that this would happen? So, is the Brazilian government really dealing with the spread of the virus in the way it should do? And again, all these factors, which are cultural factors, because maybe in Lebanon, it was, which is a wonderful country with a wonderful people, very knowledgeable, very good, but the way that risks are managed in Lebanon is very different from the way that risks are managed in the United States. Let me tell you this. When I'm riding with my motorbike or my car through the American roads, right? There are at least 10 different traffic signs warning me that in 100 meters there will be a specific traffic situation. They tell you the curve is approaching. So please, there's an intersection in 100 meters. There's an intersection in 50 meters. There's an intersection in 10 meters. Here is the intersection. So there are societies that deal with risks in a very cautious, ginger, careful way. And there are societies that deal with risks in a different way. So would you tell me, Mudita, that this will not affect the way that arbitrators and especially mediators would solve a specific conflict? of course, that cultural awareness of the way societies deal with risks affects, I mean, totally the solutions that come up. So the statutes, the code expression of the provisions of a written law cannot really respond to the richness of the life situation, especially in an international setting. So what is very important for the mediator and for the arbitrator is to be culturally literate. I don't need to speak Farsi. I don't need to speak Arabic. I don't need to speak Hebrew, but I need to speak your cultural language. I don't need to speak Sanskrit, but I need to speak fluently and competently the cultural language of the parties. And here comes my concern, how young people like yourself, Mudita, will have the opportunity of learning this language without traveling to Rio de Janeiro and see how the shanty towns are organized, and see how Brazilians deal with risk, to see how they manage to, cope with sanitary regulations when we export meat packing products to India, right? Or to Saudi Arabia. Are we complying? Are we really complying with Sharia law? Are we really complying when we send our products to, to Lebanon, for instance, or to to Iran? And this is a question that has to do with cultural awareness. So force majeure is something that must be seen, because in what? And only what if China had warned India, Nepal, and some other South Asian countries a month before? What would maybe be but again, would this be required? Would this be reasonably required from a culture in which most of the people, even high-ranked officers, they follow rules, they follow orders, they are not encouraged to think by themselves? It's a very authoritarian, sorry to say that, the culture in some specific countries. So can I, as an arbitrator or as a mediator, ignore this cultural constraints, this cultural restraints over some legally relevant behavior? So that's how I respond to your question.
Thank you, sir. So there are a few more
You're very
questions.
well. Go ahead. I'll try to be more, briefer. Go ahead.
Do you think it is necessary for the arbitrators and mediators to understand the pattern of behavior of the opposite party, or understand the behavioral norms for the commencement of the proceedings?
Of course, again, in the international arbitration, commercial arbitration setting, I will be facing, as a legal counsel or as an arbitrator, a different, a cohort apart. If I'm an arbitrator, I'll have a different arbitrator who had learned law in a different setting with different norms. For instance, India is you've been existing as a culture traditionally for thousands of years. I'm first generation in Brazil, right? I'm basically European, but I've learned law according to the civil law trend, not the common law trend. So if I cannot understand culturally the language, the cultural legal language that my partner, let's say Dr. Kumar, speaks, how would I craft along with him a good award, right? So if I'm a legal counsel, how will I communicate to the arbitrator my point of view if I'm not able to really read in his eyes? And I'm not, and the problem with culture, the problem with cultural literacy, the problem with the cultural language, and it's not the problem, this is the advantage, is that you smell it, you listen to it, you taste it. It is not something that you read in books and then, yeah, all right, you are done. Of course not. You have to learn it by living in that specific place. Of course, Mudita, I'm seeing your eyes, I'm seeing your expression, I'm seeing your body language, very restricted to this screen, but this is much different than being there and knowing a lot, I mean, knowing what your culture really is. So again, not only the law is only the tip of the iceberg, and it is very important. But if you don't take into consideration, well, Titanic, you remember the ship, biggest ship, Titanic ignored, the bottom of the iceberg, and you know what happened. Almost everybody died. So the tip of the iceberg is easy to see. Anyone can see it. The law, I can learn it. I can study. I can try to read your books and everything. But what about what the 2/3 that are below the water line? And this, the only way is to, be soaked into that culture. And again, this will become more and more common because we cannot apply the cold letter of the law to a trade conflict that happened now in this pandemic, because they're much more than just objective considerations to really pay attention to. Go ahead, Mudita.
Thank you, sir. So, what are the tips for a young, inspiring arbitrator to become a successful arbitrator, and how can one start, and what are the tips to succeed?
Well, let me tell you this, Mudita. There is this quite old writer in my country, right? And he was asked this same question. They asked him what was his advice to young people, and mind you that he responded, "Get old." Of course that I'm joking. Of course that I'm joking, right? So first of all, you need to be patient, right? This pandemic, young people, they are, most of them, they already bring in their DNA a lot of advancements. It's like you have the iPhone 10, right? Which maybe is myself. Dr. Kumar is the iPhone 20. You are the iPhone 30. New versions, revised, better equipped. You study a lot. You know a lot about the world and everything. So this is something. But second, the important thing is to understand that that law doesn't come from nowhere, from cloud nine, right? It is a cultural, a social, an historical product of millennia of development, right? So in your DNA, Mudita, there are the origins of the whole Indian and the whole world civilization. And you need to understand that this will manifest somehow, even if we don't notice this at once. Because one of the features of culture is that it is pervasive, but nonetheless, notwithstanding being pervasive, it is mostly unnoticed. we don't speak of it because it comes naturally, right? Culture is what comes to your mind when you don't remember any other thing. It's the first thing that comes in the morning. That's culture. Your familiar culture, your national culture, your religious culture, your legal culture, right? So be mindful of this. Try to be aware of this. Study the law. Be very committed, but also listen to those guys that have been working longer on the field. Be patient. Let's wait for this pandemic to recede, and it will recede eventually. It might take 1 year or two. I know it's difficult. It's difficult. I was once, as you are now. I was not born this way. You know, I was 20, 25 once, and I knew I was restless. Okay, be patient, right? Study, observe, listen, learn with your nose, learn with your ears, learn with your eyes, learn by reading, learn with older professionals, with competent young professionals as Dr. Kumar, and go for it. Be prepared to make mistakes and begin all over again every single day. Every single day we have the sun coming up, right? So, and everything begins over again. So that's my advice. Pay attention, listen, and go on with confidence. That's it. You will make the world the same way that we did 40 years ago.
Thank you so much, sir, for sharing your knowledge and making it an insightful session. I would like the same question for Sir Mrityunjay Kumar. So, what are the tips for young, inspiring arbitrators to become a successful arbitrator, and how to start, and what are the tips to succeed? What is your input regarding this?
Uh, Basically, Professor Jair told everything, but just to come up in pointers, find a good mentee. First point when you are in college or you are you are budding or you have already started your practice, find a mentee because guidance has a important role. And I can give you one example when I was going for my higher studies in Melbourne. So I did it on my own, and I found many things which today I consider if I would have been guided on that, I would have been somewhere else today. But just because of lack of guidance, I could not perceive those opportunities in advance. So when I perceived it, it was already elapsed. So mentee is more important for you. Mentor is more important for you. Find a good mentor who can mentor you in your professional life and personal life as well, because personal life is also important. Like the professor Gevaerd mentioned, etiquette and the cultural language. So that is what people remember about. They might not remember your professional knowledge. They might not remember your skills, but obviously they will remember your cultural language. So that person, Mudita, I met her on the store and she was quite good. Her behavior was quite good. She behaved like well. So they remember these things. So personal life is also good. The second point is, apart from being finding a mentor, as Professor Gevaerd mentioned, hard work. There is no shortcut for success. So it's everyday practice. If I'm today, if I'm able to speak on something, so it is my experience in that particular field. Then only I am able to talk about viewpoint and able to speak to it. So normally in social media world today, people see the professor mentioned the example of athlete. So just to refer that way, people see the tip of the iceberg, not the bottom of the iceberg. So that bottom is hard work. So if you encounter any success story and all those, don't be discouraged. The only way is they also did their part on hard work and labor and learning and continuous practicing. So these are the 2 pointers I would say. Find a good mentor, keep practicing.
Thank you, sir. I would like to thank Mrityunjay sir and Jair sir for taking out time from their busy schedule and throwing some light on this growing field and making it an insightful session. So it was an honor to have you both. Now I would like to invite Dev for vote of thanks. Over to you, Dev.
Thank you, Mudita. Am I audible?
Yes, yes, you are.
Okay. Very good afternoon to one and all present here. I, Dev Tijnani, a research assistant of the student division of Legal Desire and a member of the Alternate Dispute Resolution Department, considers it a great privilege to propose a vote of thanks to all the individuals who've been a part of this virtual conference and made it a memorable and successful conference. Today, my words are not enough to express the gratitude that I have. On behalf of the Alternate Dispute Resolution team of Legal Desire, I would firstly like to thank Mr. Anuj Kumar, sir, for making this event possible today, despite the current pandemic situation, thereby ensuring that the spread of knowledge is not curtailed across the globe. Next, I would like to sincerely thank the guest speakers for today who took out time from their busy schedules and graced the conference with their presence. I would like to take the opportunity to first thank Mr. Mrityunjay Kumar, sir, who provided us with his great knowledge and insights on the key considerations that the parties need to understand whilst conducting a virtual hearing. Thank you so much, sir, for enlightening our viewers and the entire team of Legal Desire. Next, I would like to take the opportunity to thank Mr. Jair Gevaerd, sir, for providing us great insights into how cross-cultural awareness can help neutrals navigate the COVID-19 international trade conflicts. It was indeed great to have you, sir. So your insights on international trade conflicts has certainly thrown light upon a number of issues which I'm of the opinion a lot of individuals may have not been aware of. So thank you so much, sir. Next, I would like to take the opportunity to thank the entire team of Legal Desire for providing us the platform to conduct this online conference. And lastly, I would like to thank the Alternate Dispute Resolution team for putting up a great conference today. With this, I would like to mark the end of the first day of the 2 days virtual conference on the future of ADR in the pre and the post-pandemic era. It's my humble request to all our viewers to kindly join us tomorrow at the same time, that is 1 p.m., for the second day of the 2 days virtual conference on the future of ADR in the pre and the post-pandemic era. Tomorrow, we'll be having three panelists on board with us, namely Senior Advocate Aruneshwar Gupta, sir, Advocate on Record, Advocate Pallavi Pratap ma'am, and Advocate Sushila Sarthi ma'am. It is indeed going to be an insightful session tomorrow as well, so don't forget to join us. Hoping to see you all tomorrow. Thank you and have a great day ahead.
Thank you. Thank you very much.
Thank you very much. Thank you, Professor.